Good afternoon, everybody. My name is 12 Gauge. I am your host to the channel. Welcome. I hope everybody's having a wonderful Tuesday evening. I'm doing great this evening. I'd like to welcome the people that have recently subbed to the channel. Thank you so much for subbing. Hope that you find something that you're looking for in the channel. And those of you that keep coming back and watching, thank you so much for doing so. I've been in other people's comments and live streams and stuff like that. And I've even left comments. And today just kind of rubbed me the wrong way. Y'all know how I am as far as who I am and what I'm about and the values that I hold dear to myself. And one of the things that I don't understand is how it's okay for individuals to call names and, even attack you. But yet, you don't hold anybody else accountable when they make statements without any receipts. You know, um, this true crime stuff is really sometimes infuriating and sometimes it's very childish to me because, I don't know. I was very angry earlier, not because of what was said to me, but because of the concept that it was said. And, you know, people are right. I just need to stay over here in my neck of the woods where I can speak with freely what I want. People can either come in and enjoy it or they can choose not to be in here, and I guess, I try to give other creators the benefit of the doubt, to try to get them to show me something that maybe I'm missing that is causing me not to see what they're seeing. And every time their subs show me exactly what the creator is all about. And it's a sad sight, you know? But I just wanted to get that off my chest because I am an honest person and I don't believe in hiding anything from anyone, especially if it's going to paint me in a negative light. People try to do that all the time on these YouTube streets and it's ridiculous. Adults calling people names, adults calling out other people they don't even know. I mean, it's ridiculous. And I may have started it, but it wasn't my intent. But when you're going to blatantly say something that goes against what I do for a profession, I do and have worked with law enforcement for a long time. And for people to blatantly just say that the police are incompetent and they didn't do certain things in certain trial or certain cases, it's almost like you're saying, you know more than anybody else that actually does that for a living. It's very frustrating at times and I just spoke my own solution. I'm just gonna stay over here on my side of the street. Leave everybody else to their insanity. I'm gonna continue what I started the other day as far as the court process. Um and I'm gonna continue to give commentary on it. I hope that y'all enjoy this because I'm preparing a PowerPoint as well to discuss the difference between the uh, grand jury and the preliminary hearing. I was doing some research on that earlier. I talk about this stuff all day long at work, and I just try to educate people and not showing them that they're wrong, but the fact that some things are not as right as you think they are based on the process. Like there's really people that think that you can you can find something on YouTube and it's going to free the person that's guilty or not guilty, okay? that's sitting in jail accused of the crime. Never in my lifetime have I ever seen so many people going toward the individual that's sitting in jail and not siding with the victims. I've never seen that before in my life. In any of the cases that I cover, there's people that side with the individuals that commit the crime. And it just doesn't make sense to me. But I hope that you enjoyed this presentation on the prosecution that I started the other day, and we're going to go right into it. Recent high profile white collar prosecutions, for instance, have seen defense attorneys submitting testimony and evidence to the jury about the client's lack of knowledge of accounting practices and other financial information. Prosecutors, on the other hand, usually provide memos or emails as evidence that an employee of the corporation did have knowledge of fraud and other criminal and regulatory violations. Evidence is presented to both sides in these adversarial hearings to provide compelling arguments for and against guilt. Depending on the jury's interpretation of this evidence and their opinion about whether the defendant was aware of the criminal actions, corporate malfeasance, for instance, perhaps are found guilty or acquitted. Comparing the criminal court to a game being played out from beginning to end is not new. The game-like nature of the courtroom is reinforced by using court-relevant terminology such as sides and prosecutorial or defense strategy. Prosecutors are on one side and use a particular strategy that they believe will enable them to win the game. For prosecutors, a win is a conviction against the accused. For the defense side, a win is the defendant's acquittal. Prosecutors and defense counsels are often labeled as players by different writers who seek to categorize courtroom procedures in certain ways. The law may not always be seen as a normative system where the most moral person wins, but rather where the more skillful using the better strategy will win the game by defeating the other player. The adversarial system of justice in the United States is rooted in the tradition of English jurisprudence dating back several centuries. In U.S. court, the key players, prosecutors, defense attorneys, and judges are the courtroom work group. They are bound to observe standardized rules of criminal procedure as well as well-defined ethical code. Thus, there are specific rules governing the order in which a case is presented against the defendant and the response from defense counsel. Besides following a predetermined pattern of protocol for presenting a case against and for a defendant, other rules exist that govern the nature and types of evidence and witnesses who may be called for either side. So, what this has said is basically that there are many. Let me see if I can fix that. Okay, is that better? Is that better? Like I was saying, there's many comparisons to this being a game where both sides are trying to presumably win the contest. This would be said that the prosecution is trying to elicit a conviction where the defense is trying to exonerate their client. Simple as that. Each side attempts to manipulate the evidence presented in ways that enhance their respective argument. So that says each side. That doesn't say the prosecution tried to manipulate. It says each side. That means both sides trying to manipulate the story or the evidence presented in the ways that enhance their respective arguments. So if you have evidence to show that this person was there, you're going to try to speak on this evidence in a manner that leaves no reasonable doubt. But if you're the defense, you're going to speak on the evidence against it to leave reasonable doubt to show that your client could not have been the one that did this crime. The witnesses are examined and cross-examined by the different sides in an effort to bolster their arguments. Ideally, the side with the most persuasive and compelling argument, either against or the accused, or for the accused, wins. So, like I said in the last live when I was talking about this, the Casey Anthony trial. I keep bringing that up because that is one of the ones that really blew my mind when it comes to, you know, there being a lot of physical evidence, there being a lot of evidence against Casey Anthony, but her lawyer got up there and totally blew all the evidence away. He manipulated his words and the evidence to a point where there was reasonable doubt in the jurors' minds. So therefore, she was she was acquitted. She was allowed to walk. Did she kill her child? If she didn't do it, I'm sure she knew who did it. Because there's no way that your child is able to go missing. And most of the stuff is found in the car that you're driving, in the trunk, no less. So if y'all don't know anything about the Casey Anthony case, you might do some research and let me know what you think. Juries decide the facts in the case before them, and their deliberations most often favor either guilt or acquittal. On rare occasions, juries may not be able to reach an agreement as to which side the prosecution or the defense has the most persuasive argument. In these instances, juries are deadlocked or hung, and mistrials are declared. Subsequently, the adversarial process begins anew with another trial. In each trial proceeding, it is expected that both sides will adhere to accepted ethical code and conduct themselves accordingly. So, the rules of criminal procedure are the rules legislatively established by which a criminal case is conducted. Law enforcement officers, prosecutors, and judges use rules of criminal procedure in discretionary action against suspects and defendants. Ethical code are canons of professional responsibility articulated by professional associations such as the American Bar Association. The witnesses are persons who have relevant information about the commission of a crime that may incriminate or exonerate a defendant. So, as I've always said, and this is what I don't understand when people start to attack me when I make a statement, usually, is I've always said not only are they trying as hard to exonerate this individual once he gets to trial, they're trying as hard to convict him as well. So, the process is based on checks and balances. So you're telling me in the very beginning of a lot of these cases where you said that there's no evidence or there's only circumstantial evidence that the police, the investigators, hell, even the district attorney before they brought it before the grand jury could have acquitted or dismissed the charges. So you're telling me that in a lot of these cases, they go through all these hoops and all these professional people, and not one person goes against the status quo and stands up for this individual if they were innocent. That's usually not how it happens. Not how it happens. Throughout the criminal trial, evidence is presented by both sides for persuasive effect. Prosecutors usually present inculpatory evidence. Let me see if you guys remember what that word means without Googling it. What's inculpatory mean? Let me keep going. Or testimony and other forms of evidence that tend to show the guilt of the defendant. So this is what the prosecution is trying to show, inculpatory evidence. For instance, the defendant's fingerprints might have been found on the murder weapon, or eyewitnesses may have seen the defendant pull the trigger of the gun that killed the defendant. And I've seen in one case where people are saying this individual didn't commit the crime, but he could have been this type of person. They've used the word cleaner. He could have been the getaway driver. He could have been all this other stuff. So this is how little people know about law. Even if you're the cleaner and you walk into a crime scene, the moment you walk into that crime scene, you're just as guilty as the person that committed the crime. If you're the one that with the getaway driver, or you were one of the person driving around the crime scene and you were anywhere near there that they can put you in close proximity of that crime at the time it happened, if there was anybody with you that committed the crime, guess what? You get charged with the crime as well. It's called accessory to the commission of a crime. So all these theories that say, well, this individual might have not did it, but if he was anywhere in the area and they can prove that, guess what? It's an accessory to the crime. Hey, 007, thank you. You're right. For instance, the defendant's fingerprints might have been found on a murder weapon, or eyewitnesses may have been seen the defendant pull the trigger of the gun that killed the defendant. This evidence would be considered inculpatory because it showed the guilt of the accused. By contrast, defense counsel introduces exculpatory evidence. So this is for the defense. What would exculpatory be? Or this could be testimony to the other forms of evidence that show the innocence of the defendant. This is during the trial. This is not leading up to the trial. There is not a trial by public opinion, no matter what people want to say. This is all the stuff that's presented at the trial. For example, one or more persons can testify that the defendant was with them at the time of the murder was committed. Credit card receipts or video surveillance from restaurants or shopping malls may indicate that the defendant was somewhere else when the crime occurred. And don't you think that if they had this evidence, because this is the evidence that the prosecution would have been prevalent to as well. So if you have this evidence, don't you think it's going to exonerate you? This is going to be part of your alibi. Thus, alibis and other relevant information may show that the defendant couldn't have been the one who committed the crime when it occurs. So if the defendant couldn't have been the one that committed the crime because they have video evidence, receipts, things like that, they don't have anything to worry about. And there's those two words again. And let's move on. Let's talk about the prosecution. Besides the judge who makes important rulings in criminal cases and oversees trial proceedings, the prosecutor, I feel like I've read this before. Let me see if I've read this before. Let me get down to the role because I think I've read the top, or just repeating itself. The roles of the prosecution. The primary roles of all prosecutors in criminal courts are to represent the government's interests and pursue the criminal charges against those alleged to have committed crimes. For state's attorneys or district attorneys, their roles are similar throughout the different U.S. jurisdictions. The summary of these roles are as follow. To screen the cases for prosecution, to determine the best strategy for prosecuting cases, to make case assignment to assistant district attorneys. And by the way, I've seen assistants that are just as vicious as the district attorney or more. This trial that I went to a couple weeks back, the assistant district attorney was the one who nailed the case because the district attorney wasn't bringing the case. He wasn't giving it life that it needed. The assistant, she brought it, and I believe she was the one that closed the case for the state. To interview prospective witnesses against the accused, to work closely with law enforcement officers to determine the nature of inculpatory evidence against the accused. As I was talking about earlier, during the grand jury, the prosecution shows the evidence that they have against the accused. And most of the people that are the witnesses that the grand jury is listening to are the police officers. They're the investigators. They're the ones that gather the evidence at the crime scene. The defense is not usually at the grand jury hearing, but they have the right to be. But that means that the defendant can be examined. They can be asked questions. So by the grand jury. So a lot of times it's best for them not to even be there. In the federal system, the U.S. attorney's offices in the various federal districts are charged with the following broad rules: to prosecute all offenses against the United States, to prosecute or defend for the government all civil actions, suits, or proceedings in which the U.S. is concerned, to appear on behalf of the defendants in civil actions and suits or proceedings pending in the district against collectors or other officers of revenue or custom for things they have done for the recovery of any money exacted by or paid to them, to institute and prosecute proceedings for the collection of fines, penalties, and forfeitures incurred for violation of any revenue law, to report as the Attorney General directs. So, you heard me talking about screening the cases for a trial. Screening cases mean to assign priority to different cases on the basis of which ones are most deserving of prosecution. The screening function of prosecutors is very important as it relates to the obtaining guilty pleas from criminal defendants. Most convictions are obtained through plea negotiation between prosecutors and defense counsel, where some form of leniency from the prosecution is extended in exchange for a defendant's guilty plea. So, this is talking about plea bargaining. So, this is where plea bargaining usually takes place. Thus, prosecutors have broad discretionary powers concerning which cases to pursue and what types of offers to extend those charged with crimes as inducements for guilty pleas. Prosecutors have the power to determine the types of cases that will be prosecuted more vigorously than others. Domestic violence or child abuse cases may receive high priority in certain jurisdictions because of the strong interest from community or religious leaders. Prosecutors and police officers can assist these leaders in the prevention and deterrent of domestic violence by vigorously prosecuting and seeking maximum penalty in domestic violence cases. Organized or gang-related crimes may have high priority or prosecutors in certain large urban jurisdictions. Prosecutors seek convictions, and prosecutorial effectiveness is often gauged by the number of convictions they obtain. The greater the number of convictions, the more effective are the prosecutors. Therefore, it is the prosecutor's interest to select cases for prosecution that are the easiest to prosecute and obtain a conviction. That's interesting. Even in a murder trial of any sort, you have to prosecute it, okay? Because it is a murder trial. But would you be sitting on the evidence if you thought that you couldn't win it? Honestly, would you be sitting on the evidence? You don't want to show your hand to the other side. Because as you just heard me say, it's a manipulation between both sides. Plea bargains sometimes are beneficial because they're more lenient towards the defendant if the defendant indeed was guilty and they're facing harsher punishment. Like, let's say they say, well, okay, we're going to drop these charges and we're going to stick with this one because this one holds the most time. So instead of 10 years, we're going to give you 7 years if you sign. And more often than not, I bet you that person's going to sign for 7 or even 5 years, because it's easier to do 5 years because sometimes you don't even get to the unit doing 5 years, at least here in Texas. I mean, I don't know where other states are, but in their criminal justice stuff, I think most places are pretty much universal, but there's a lot of states that are a lot more lenient, and there's a lot of states that are a lot more harsh towards that. So I hope that answers your question. So I'm going to read a little bit more about the court strategy, and then I'm going to go into the grand jury and preliminary hearing because we didn't get to see this in some of the cases, but I want you to understand it. Um, a prosecutor's vigor, persistence, and demeanor are often sufficiently convincing for jurors in the courtroom. Prosecutors must decide whether these cases are worth pursuing, where the conviction of the accused is less of a certainty compared with the case with considerable inculpatory evidence. Determining court strategy, prosecutors must devise their theory on how and why the crime was committed. They must attempt to link the defendant to the crime in such a way that the jury will be convinced beyond a reasonable doubt of the accused's guilt. There are many potential explanations for a defendant's conduct relative to the crime. It is not necessary that the prosecutor selects the true explanation, only a plausible one. The theory of a crime and its commission is often suggested by the nature and the quality of the evidence against the defendant. For example, if one spouse was violently killed and the surviving spouse stands to collect on a $1 million insurance policy, then the fact provides a motive for why the surviving spouse might have committed the murder. However, if there's another person with whom the surviving spouse has had an affair, then the motive for the murder may be love and not money. It is fairly easy to see how different spins can be given to any criminal scenario. So that last statement right here. Good grief. I'm going to get on here and say, hey, does anybody have any batteries I can have? It is fairly easy to see how different spins can be given to any criminal scenario. So that means that you can spin it any way you want. Any way you want. And let me get to the grand jury and preliminary, because we didn't get to see these. So let me kind of educate you on what they are. Okay, the grand jury and the preliminary hearing. The next step after arraignment usually whenever the person's arrested and they're arraigned for their crime, is a decision about whether there's enough evidence, probable cause to move forward with the charges or the prosecution. There's a very low bar to establishing probable cause. So it's easy for the prosecutor to get the approval to continue with prosecution. That's pretty much what it looks like, I'm sure. Hear ye, hear ye. The next step after arraignment is the decision whether there is enough evidence, probable cause, to move forward with the charges or the prosecution. Depending on the place and what crime someone is being charged with, this determination can happen through a grand jury or a preliminary hearing. And in one of the cases that we all love to talk about and all the things that we like to say about it, we didn't get to see a preliminary hearing. So we heard that there was a secret grand jury. And I'm sure that the wording of secret made instantaneously people not trust that process because they already don't trust the process. So they're all called secret grand juries. That means that they're done in secrecy, meaning that nobody knows where, when, and how they're going to happen because they want it to be the fairest thing that they can do regarding this trial that's fixing to happen. They want to see if there's enough evidence for the indictment to come in so that they can continue on with the process. Whether the decision enough evidence for the trial for the individual to be indicted. That's neither here nor there. That's neither here nor there. Like, it can happen to any of us. So, if you put yourself in harm's risk, oh, there it is. Okay, it says first, let's tackle grand juries. The grand jury is a one sided proceeding where the prosecutor presents evidence to a group of people selected from the public, known as the grand jurors. The defense is not allowed to participate in the grand jury. The grand jury decides whether the prosecutor has probable cause for an indictment, which is necessary for the case to move forward. If the grand jury does not find that there is probable cause to support the charges, it has to issue what is called a no true bill and the charges will be dropped. So, do you believe at any time that in one of these cases, if there wouldn't have been enough probable cause to support the charges, they would have dropped it? This is 4 counts of murder, okay? Would they have dropped the charges? Of course they would have if there wouldn't have been enough evidence. I don't want to get into the semantics of, well, it's circumstantial, it's this, it's that. The fact of the matter is, this grand jury indicted. That's the end of the result. They indicted. The grand jury normally hears many cases in quick succession for a duration of their service, which can last for weeks or months. People receive notices in the mail and they must come to court to serve on the grand jury. They serve for a period of time, and during that time, the jurors hear evidence, receive instructions about the law, and they are asked to vote on whether or not the evidence is sufficient to establish that a crime has occurred. And I know what you're going to say. In the case that I'm talking about, the 12 gauge, the grand jury said they needed more evidence. Ah, I beat you to it, friendly snake. I knew somebody was going to say that. The prosecutors come in one by one with their individual case and lay out the evidence to the grand jury, usually in the form of witnesses, documents, and surveillance video for anywhere from 15 minutes to several hours. We probably heard between 5 to 7 prosecutors each day. So there's a lot of indictments going through here, man. They're hearing a lot of cases. Defendants have a right to testify should they want to, but their lawyer can only advise them, not make arguments on their behalf. Once the grand jury has heard all the evidence, the prosecutor reads the charges and their definitions out loud. A court reporter is tapping away. Then the grand jury is left alone to discuss the evidence and vote. If 12 of the 23 people have find that there is legally sufficient evidence, sufficient. It doesn't say that there's overwhelming. It says sufficient, meaning that This evidence supports the charges. So, we have a reasonable cause to believe that a person did what they're accused of. The jury indicts. An indictment is not a judgment of guilt or innocence, but it clears the way for the question to be decided in a plea deal or a trial. That's it. That's it. Nothing more, nothing less. People make this so difficult sometimes. They like want to fight you for every word. This says legally sufficient evidence and reasonable case to believe that a person did what they're accused of. The jury indicts. And then it keeps going that an indictment is not a judgment of guilt or innocence, but it clears the way for the question to be decided in a plea deal or a trial. So at that point, they've been indicted. Grand juries are different from trial juries. The trial jury decides whether the evidence is enough to establish beyond a reasonable doubt that a person committed the crime. A grand jury decides based only on information the prosecutor presents, whether there is enough evidence to go forward with the case because they believe, again, only based on information the prosecutor presents, that it's more likely than not that a crime occurred and that the person accused was responsible for it. That is a very low burden of proof. And have people been indicted that were innocent? Of course. It works both ways. But to sit here and say one sided when you don't take into account both sides, that's a very biased opinion that some people may possess. And that's okay. The illusion of an indictment is the grand jury is supposed to create a limit on a prosecutor's power by making them prove to a jury that they have the legal basis for pursuing charges. The reality is that is not how it functions in practice. In most places, the prosecutor decides everything about the grand jury. It is the prosecutor's show, and their objective generally is to get an indictment. Of course. Why would they be going to the grand jury if they didn't want an indictment? But they also have to present the evidence. It's not like the prosecutor just goes up there and says, "Hey guys, I know that we're here secretly, but I want to plead to you to just say, hey, this person did this crime, and I know they did it because I just have a hunch. I have a hunch they did it. So let's indict them." Okay, you're right. Let's indict them. No, it doesn't work that way. You got to show evidence. And unless you were on that grand jury, you don't know what evidence was shown. If you want to be fair, you can't say that what the family releases is not credible. At the same time, what you release is credible. It doesn't work that way. So to say that the family released that the certain things that the grand jury people obviously talked to them about, nobody knows that. They have control over what charges to present, what legal guidance to offer about how the grand jury should make a decision, which witnesses to present, and whether to go forward with the grand jury in the first place. Prosecutors want an indictment, and the grand juries usually agree. There is a reason we have the saying that most grand juries will indict a ham sandwich. I'd hate to be on a grand jury because these are probably some of the things that are going through their minds. If I ask a question, now I'll be interrupting. Can I even do this? Wait, should I nullify or vote no? I'm confused, but the prosecutor seems smart. I'll just listen. So if I vote yes, she goes to jail or the illusion. Grand juries have the power to keep prosecutors in check. The reality. While grand jurors do technically have the power to nullify and to ask questions of the witnesses, they often are not informed of this power, called jury nullification. Additionally, it is actually a very radical and difficult move for a layperson in the face of a judge, a prosecutor, court officers, other jurors, and general societal conditioning to vote no in the face of obvious probable cause. Even asking probing questions can feel difficult and is often discouraged. So, another illusion is grand juries are transparent hearings where both sides are able to present their side of the story. The reality, the grand jury proceedings happens entirely in secret. No members of the public or media are allowed to attend, not even the person accused of the crime, nor the defense team can be present, except the person accused of the crime can be present to testify, and only during that time they are testifying. It is very rare for an accused person to testify since their lawyer cannot ask questions and you're not able to present to hear what other witnesses say. The grand jury is a one sided presentation. There are many paths to prosecution, and grand jury presentation indictment is just one. Not all states use grand juries. Each of the 23 states that do use grand juries does so differently. Some states use it for felonies, others for a range of cases, including even misdemeanor cases. Okay, so what's a preliminary hearing? In some places, instead of grand juries, or in addition to the grand jury, there's a preliminary hearing, sometimes called the probable cause hearing. Both the defense and prosecution attend. See, this is what should have been done. But for whatever reason, they didn't want to have a preliminary hearing. And I don't believe there was a nefarious reason. I believe that for whatever reason, the grand jury indictment was probably a lot more beneficial to one side than the other. I don't understand why they did it. The purpose is similar to the grand jury to decide whether the prosecutor has enough proof to charge a person with a crime. However, instead of a jury, the decision is up to a judge or magistrate. During a preliminary hearing, the prosecution will bring witnesses, usually police officers, and the defense can ask questions. The illusion is preliminary hearings are more fair because the defense can actually attend and participate. The defense can try more explicitly to get the charges dismissed, whereas in the grand jury, it's the black box. They have no idea what's going on. The reality is, in both grand juries and preliminary hearings, police officers are the star witnesses, and they are typically seen as more credible than anybody else. The defense may be leery of presenting their full case at the preliminary hearing because there are so many unknowns at this early stage and don't want to risk showing their hand to the prosecutor, giving them an advantage. So, what are the key takeaways? Probable cause is a very low burden of proof, and so it's very easy for a prosecutor to get an indictment and continue with the prosecution. The grand jury functions as a rubber stamp, not as a check on the prosecutor's power. Jurors do not have the power to nullify charges, although they are often not informed of this power and it can be difficult in practice to execute. We can definitely fight to open up and eliminate grand juries and to teach grand jurors about jury nullification. So, what do y'all think about that? What do you think about grand juries? Do you think it's fair? Do you think it's unfair? Do you think a preliminary hearing should be done in most cases? I mean, what's your opinion on that? I think they gave as little as possible because I think they knew that they were going to place a gag order. Very interesting, Texas. So preliminary doesn't see guilty or innocence. No. It's whether to indict or not to indict, if there's enough evidence to indict the person. No, the defense generally doesn't ask for a plea deal. So I think if they asked for more evidence, they would have had to comply. I'm leaning toward agreeing with you there because, they could have, like, I'm being very facetious right now, but they could have three pieces of evidence, right? And determining how the prosecution or the state weaves the story where these three pieces of evidence are so strong that it convinces the jury that this is the person. That's all that's needed. And the defense doesn't have a very good way of disproving this evidence. It's actually how your lawyers present the case. I mean, a lot of it is. A lot of it is how the lawyers present the case. So if your lawyer is able to present a good case, chances are you're going to get off. It's just court appearances can stretch on for months or years before a trial happens, if it ever happens at all. During this time, the defense will make legal requests for the prosecution to turn over evidence, but there are not strong mechanisms to ensure that they do so. And that's what we've seen in one of the cases is the defense is making motions for the prosecution to turn over the evidence. If a judge or grand jury finds probable cause to continue prosecution, the next step is a regular court appearances until the case goes to trial. It's dismissed or resolved through a plea bargain. So those are the three things that can happen. The case will go to trial, it's dismissed, or it'll be plead. And at this point, these are the ways that this defendant will be taken from the position they're in currently. These court appearances serve a range of different purposes. Lawyers file motions, and the prosecutor and defense update the court about their investigations and their preparations for trial or plea negotiation. These court appearances are supposed to help each side prepare for trial and for the judge to rule on important matters regarding the kind of evidence that can be introduced at trial. The illusion. If probable cause is found to continue prosecution while there may be few court appearances in between, a trial will begin almost immediately, like on Law and Order. The reality. This time period for court appearances can actually be lengthy, depending on the case. In some cases, court appearances can stretch on for years before a trial even starts, if it ever happens at all. Court congestion, many people being prosecuted at the same time, can prevent cases from being resolved. The high stakes of a case mean that the defense may want to delay a prison sentence, especially if the accused person is free pretrial. A judge or court administrator can also delay a case by claiming that the courts are too busy to hold a trial or that a co-defendant's case must be tried first. Sometimes the time period can be lengthy because the case is complex. Each side may have witnesses and experts to prepare. Other times, the reason there are many court appearances is because the prosecutor's witnesses do not want to cooperate, but the prosecutor does not want to admit defeat. Listen to this. Take the case of Carlos Montero, who spent 7 years on Rikers Island before taking a plea to time served. Neither the prosecution, courts, or defense would take ownership over the delay, instead pointing fingers at each other. At the time he was on Rikers in 2015, at least 400 other people incarcerated there had been waiting at least 2 years for their cases to go to trial. While time limits for prosecution can be extended by both the prosecution and the defense, it is typically far more advantageous and biased toward the prosecutor, who does not want to, nor do they have staffing to, bring every case to trial. And that's one of the reasons they plea out, because they don't have the time or the staff to take every one of them to trial. That's why they screen them. Obviously, a murder case is going to hold preference over, a drug case. While there are technically some limitations on how long the prosecutors can drag out a case, i.e., speedy trial laws, which In one of the cases, the individual um, waived their speedy trial. Those time periods have a lot of loopholes, are vague, or not enforced. Prosecutors can also find ways to get around the rules because of the high number of criminal cases. For example, prosecutors can declare themselves ready for a trial and thus avoid running out of the clock when there are not enough courtrooms or judges to actually start the trial. That means the prosecutors can take their time before being forced to resolve the case or take it to trial. They control the time. In 2018, an expose of internal training documents from District Attorney's Office in Bronx, New York, revealed that prosecutors were being trained in courtroom techniques with the explicit goal of stretching out cases. This prosecutorial practice of manipulating the system to delay cases in order to secure guilty pleas is not unique to the Bronx. Regardless of why the delays happen, for people who are incarcerated pre-trial, the many court dates and length of a case can be torturous. The longer you spend in jail, the more likely you're to accept a guilty plea, even if you're not guilty. However, even for people who are free pre-trial, attending endless court dates comes with its own set of challenges. Having to take entire days off work or figure out childcare just to sit in a courtroom, waiting to see a judge and nothing happening with your case. For those on pretrial supervision, the consequences for health, employment, family, and more are prolonged. The accused pays the penalty for the delays, either time spent incarcerated pretrial or time spent coming back and forth to court for court appearances, unable to get on with the rest of their life. The illusion is the defense has access to all the evidence the prosecutor has gathered before the trial begins. The reality, unfortunately, no. Although there are rules that require the prosecutor to turn over evidence, only they know what evidence they have. The defense attorney doesn't get to go through the prosecutor's files, and neither can the judge. It is the prosecutor who decides what evidence to give to the defense. Although prosecutors are under obligation to turn over evidence that is favorable to the defense, there are not strong means of forcing prosecutors to do so. This leaves many people making decisions in the dark. Additionally, in general prosecutor offices can access evidence much more easily than the defense because prosecutors are government officials. They have more power, clout, and authority than the defense. Prosecutors also have more researchers, such as police officers, to conduct their investigations, and businesses are more likely to turn over evidence to the government than to an individual accused of a crime. This is what almost led New Yorker Aaron Cadra to take the plea bargain, even though he was certain security footage of the incident would exonerate him. It says the Marshall Project tells the story of this wait for evidence, also known as discovery, to be turned over. Cedrus and his lawyer, Christian Brand, said that at first he refused the plea, but as the months wore on, he began to consider it. Pending felony charges meant that he lost his job, then his apartment, and his car. His girlfriend moved on to mother's house with the couple's infant daughter, and Cedrus was homeless. Braun wondered if Cedrus accurately remembered the chaotic event or if a single punch was enough to make him guilty under the law. Prosecutors in this case turned over police reports indicating that the victim and his girlfriend had found Cedrus on Facebook, identified him as the leader of the assault, and were willing to testify. Braun filed a motion for discovery shortly after Cedrus was arrested. Under the law, the prosecution had 15 days to hand over the material or explain why it would not. 15 days passed with no reply, then 30, Braun said. Judges had few available sanctions for prosecutors who did not comply with discovery requests. More than 2 months after Braun's initial request, the prosecutor wrote that the video did not show anything, is corrupted, and email shows. Braun pushed back, and after another 5 months of wrangling, the videos appeared in her inbox. They showed almost exactly what Cedrus said they would. In the mayhem, he threw 2 punches to free the club owner's son from a bear hug. A separate fight spilled down the street where a crowd of people beat the man who was ultimately seriously injured. After a year and a half and 22 court appearances, the charges were dismissed. What are the key takeaways? During the lengthy period of court appearance, regardless of why they're stretching it for so long or who is to blame for the delay, the accused person, whether they're in jail, on supervision, or technically free, remains in limbo, in the clutches of the court system, unable to continue on with their life. There are no strong mechanisms to force prosecutors to turn over evidence. They are obligated to provide over to the defense, meaning that the prosecutor often knows a lot more going into trial, leaving people accused of crimes to make decisions about their case, specifically whether to take a guilty plea while in the dark. Court appearances are key moments of particular participatory defense campaigns reach out to the community to come to court to show the person charged and the court that the community does not support prosecution and has many other ideas about how to prevent, interrupt, and heal from the harm involved. And we'll stop right there. We will stop right there. Yeah, the judicial system is broken to an extent. It really is. Um, I'm not saying it's perfect. I'm not saying that there hasn't been times where um, there's been misjustice, but it's the only one we have, and when it works, it works. Does it work all the time? No. Just like everything else in life, there is human error there. But does that mean that every case is faulty? Does that mean that every court case is corrupt? What's better than what we have? I mean, if people can really get into office and change it, I mean, it would be a beneficial thing for the justice system to be revamped. The unfortunate is there's more criminals out there than there is individuals in place to catch them, try them, and convict them. There's a lot of recidivism when it comes to the criminal justice system. I don't believe people understand that. People go in and out, in and out, in and out, in and out. They report to probation officers, they report to parole officers, and they're either dirty for drugs, or they're reoffending, or they're not showing up, or they're living somewhere they're not supposed to. They're riding around with no insurance, no driver's license. They're not attending their treatment. I mean, there's multitudes of things that continue the recidivism. And it's just a very dire existence, you know? But you can't just give up and say, okay, well, we're going to turn it over to the people that are fighting harder to break the law than to follow it. And by no means am I one sided in any of these things, but people assume that I am. I was even called a guilter today. Again, a guilter. Crazy. Crazy, crazy, crazy. But it is what it is. I guess it comes with the territory. But I'm not a guilter. I'm very objective when it comes to certain things. You just have to support your statement with some evidence or some kind of research. Because other than that, it's just a blanket statement. It's just a blanket statement. It's like it's a blanket statement that can't be supported. And people say, well, you shouldn't have to support things with facts. Well, how other do you support them? I mean, how do you support your decision? Do you not support them with facts? when you make a decision to buy a house, are you not researching houses to buy, best locations for schools if you have children? I mean, do you not actually research things, or do you just take other people's words for it? I don't know. It just it's a very interesting dynamic this true crime community is. It really is. And I have no ill toward anybody. I really don't. Whether they believe the way I believe or whether they don't, it is what it is. I just hope that y'all enjoy the presentations. I'm laughing about it right now because I'm thinking back on some of the comments that were stated. One of them said, "Don't you think it's weird that you talk about the case and present videos on it every day?" I'm like, I'm a creator. That's what creators do. We create content. The same thing you're doing here for with this creator. You created content. You came to comment on it. I think YouTube should force you to put your real name and your real picture and everything else about you, so it takes the anonymousness of it away, where you're held accountable for your statements. I think that would be awesome if YouTube had you do that. I would put my real name out there. I've been on camera. You know what I look like. And it's not too hard to realize, where I live. I mean, I've told you. But it's just silly to me that, you know, the more misinformed the narrative, the more it's being pushed. Yeah, exactly, Paula. Exactly. Of course, it'd be dangerous, but, it would hold accountability. Then you wouldn't be able to cuss people out or call them names or all this other stuff, hiding behind a letter, you know, and a fictitious name. Is it just me, or, I mean, do y'all go around calling people names in your real life? Do you call people names like at your job if somebody doesn't go with your narrative about what you believe? Do you call them what would be a word? I don't know. I can't even think right now, but it's like you calling them a guilter. Yeah, it probably is. I'm just ready for it to be over. Then I wonder what other case will be coming down the pipe, you know? Have y'all heard anything about Summer Wells at all? Like, has anybody heard anything about Summer? Has there been any more investigation on that? Has anybody heard about Sebastian? Anything new on that? Anything at all? See, those are the sad cases, you know? Those are the sad cases. Summer Wells, Sebastian, Rogers. I mean, and countless other missing children that go under the radar that aren't important enough to even talk about. I mean, it's sad. It's sad that, if you do a show on missing children or you do a show on trafficking or something like that, nobody wants to watch that. Nobody wants to talk about that, you know? Yeah, I mean, It's almost like, really? I didn't know that. What'd she go to jail for? I didn't know that. I mean, I try to stay in my lane. I try to, just mind my own business. I sometimes creep these streets because there's nothing else to do, but I've learned my lesson. Whenever you go in, you say hi to the chat and nobody acknowledges you, it's like, okay, the guilter's here. Beware what you say. Yeah, it's easier to blame the parents. And I mean, sometimes the parents need to be held accountable, just like in the, what's her name? Maddie Soto case. That mom should be, in my opinion, should be held liable just as much as the guy that killed her. I mean, because she knew more than she let on, you know? I know, Arian, I know that, and that's the sad part. There's so much drama that you can't even really pay attention to the facts or what's been looked into. And there's still some people looking. There's still people with billboards up, funding the cause. There's some good people out there. It's just sad. There is a guy by the name of Arctic Fox. That guy is a trooper right there. Because I noticed that he's always posting missing people all over. And I commend him for that, and I was reposting stuff that he was doing there for a while. There's just so many, you can't just post them all, There's just so many, you can't repost them all. And it's like trafficking is real. It really is. It's like, where are these kids going? They're just being, they're just vanishing. It's almost like one, two, three, four, five a day. I mean, if it's not that, it's, you're hearing about school shootings, you're hearing about all kinds of stuff that is endangering our future. It's like kids have so much on their plate these days, it appears, and it's just getting worse. Yeah, if you could put Arctic Fox's page on the in the chat, Rondi, or one of you mods, that would be great because he does some hard work, man. I mean, he's always on it every day. He's posting, he's talking about it. He's really he's really the real deal about it, and I commend his hard work for it. There are some creators that are really doing great stuff on the YouTube, and it's sad that they don't get the accolade that the others do, and it's sad. I guess people don't do it for accolade; they're doing it for the purpose. But Arctic, if you're listening, or somebody listening that listened to him, I commend you, brother. I commend you for your hard work. Keep it up, man. But I was doing a little bit of missing people. I put a missing person up on my community post. The individual's from San Angelo. Let me go back to my community post and I'll read it again because I haven't heard anything else. I know the mother, so that's why I asked her to give me the information and I would post it. And I haven't heard anything else. I haven't heard whether he's been found. I haven't heard anything. So let me read it again. That way, if anybody's in the area, um, Austin area or Dallas area, And there's some misspelling because I think the mom gets nervous or she writes this so quickly that um, there's some misspelling, but I'll try to read it, okay? Here we go. It says, I put on here, hey everyone, please be on the lookout for this mother's son. She sent me this present to present on the channel. She wrote, the first 2 hours after disappearance are critical and crucial. According to the source, Texas governor utilizes missing persons clearinghouse for missing persons. Most missing adults are located within 3 to 5 days. The rest, if still alive, within the 45 days. Today makes 56 days. Lawrence was arrested for possession of a controlled substance on August 30th, 2023. He was sentenced to 350 days in state jail or medical needs Safe P. Lawrence chose to go to Safe P in hopes of not having this on his record. Due to his mental health, even though he was being provided his mental health medication needs, he was unsuccessful at Safe P and released back into the county on January 4th, 2024. He then was released to Travis County State Jail in Austin, Texas, in order to finish up the last 90 days that he had remaining on his sentence on April 25th, 2024, after 109 days in the state jail facility. He was released on July 12th, 2024. The family was aware of his own upcoming expected release date. While Lawrence was in the state jail facility, Travis County, he was not provided his mental health medications. The paperwork that was sent with him from the jail and from the medical needs unit, not acknowledged by the staff at the state jail facility. The state jail facility stated that they asked the offender if they have any physical medical needs when he was released on July 12th. He was released without cognitive clarity due to not being on the medication that he's been on since he became an MHMR patient at age 13. In excitement and anticipation for his arrival, we, all of his family, hover around our computers, staring at the TDCJ website, staying close to our phones, awaiting that phone call. He's coming home. But to our shock, the TDCJ website no longer stated that his release date was July 12th. It stated that his release date was pending. Well, no one in the family had been to jail before, so we don't know what that meant. Just assumed that since it was a Saturday, maybe they weren't going to release him till Monday. Still hovering around the computers over the weekend and again on Monday, TDCJ website says no expected release date at this time. So the best that we can come up with, he got another charge here in Tom Green County. So Tom Green County is going to come pick him up, or he caught a case there in Travis County in Austin, Texas State Jail. So after about 11 days of July 23rd, watching Tom Green County Jail roster along with TDCJ roster to give us an expected release date, exhausted from anticipation of getting that reunification call. I called TDCJ. They say he had been released on July 12th. I explained how that's not possible because of so many of us have been circling the computers and it stated that there was no expected release date. So the gentleman looks it up, and sure enough, there was an error in their system. He states that he has been definitely released on July 12th. None of the family, none of the friends, no social media had been contacted. Still not believing TDCJ's website was just possibly down. I called the jail, Travis County State Jail in Austin, Texas, to find out if he was in holding cell and waiting for somebody to pick him up and what was going on. They stated that he was released on July 12th, immediately knowing my son and knowing my family and knowing everything that he had said to all of us during the journey. None of this made any sense. Due to his medical needs, his emotional and mental needs, is very independent, codependent on family for support, the extra support that special need people have. To not contradictory of us made no sense, so we all started contacting. Being born and raised here, all of us, as well as Lawrence, we start contacting everybody, all the county in the state of Texas arrested, been made to hospitals, halfway houses, treatment centers. We're getting no one's heard nothing from him, and the jail, Greyhound bus station neither could confirm nor deny whether or not Lawrence had utilized the bus voucher received by TDCJ. So then on July 24th, my son had been missing 12 days. I called San Angelo Police Department for help. SAPD told me that my son had the right to choose to disappear if he wants to. Really? I and Lawrence's grandmother advised the officer that he also had the right to protection and assistance if he needs it, and he doesn't have the voice to ask for it. The officer sent to my home told me the same thing that the woman who answered the phone at SAPD told me there's probably nothing they can do to help because he's 31 years old and he has a right to disappear. Exactly the same thing the officer stated when he got here, as though they had communicated or somehow knew how to repeat the exact same line to me. So upon arrival, he had this standoffish attitude that we speaking, not really anything I'm going to be able to do. The officer seemed more concerned about my dog that got out of the yard as I was allowing the officer into the yard than he was about my son. I did call superiors and filed a complaint against them. They did say the SAPD is forced to wear audio and visual cameras on both the front and back of their vests, and it cannot be altered with, or the officer would lose their job. So they would be glad to take a look at the footage to see how disrespectful, disheartening, and rude the officer was. Shocked our hometown, our community, unwilling to help a member of the community, and the entire pleading family needs for assistance. I am finding our missing members, so I move. I must. A mama Austin immediately offers assistance. They open the case on my son with the intent to insist locating the family. Continue to call the jailhouse and the Greyhound bus station, everybody in every location that we can think of, because this is so unlike my son, their brother, their father, their grandchild, their great grandchild, that their cousin, their nephew that we are. We just take him back finally. I was able to get a hold of somebody in Houston, Open Record Department, who advised me that they had been able to, that he had utilized his bus voucher and was released in Dallas. She actually had an address on where he was supposed to be going to in Dallas, but not able to release that information to me. So I called Dallas Police Department, who immediately opened a missing persons case on my son. Detective in charge of the missing persons case is Detective Darby. The family is currently actively working with MHMR, but due to training purposes, the supervisors are out this week. So proof of mental health diagnosis have not been released to the family or Dallas Police Department as of yet. We need this info so DFW, PD, Detective Police, and DPS, hopeful that none that get in a missing persons case open, SAPD will assist as well to put urgency on this case, that the case required Dallas had the photo in every DPS vehicle in Dallas. The family has also contacted State Representative Drew Darby in desperate hopes for help to get needed paperwork to assist our son during these critical days. Family requests necessary two pieces of paperwork to be releases from both the Houston Open Record Department and MHMR that our loved one can be found. Someone out there knows something about my son. It's what happened with him. Please, if you know anything, please call our local police department. His mother, 325-234-0847. His grandmother, 325-212-6971, or 325-465-5039, or his brother, 325-482-7082. She says, Lawrence, if you hear this, I would love you forever. I would like you for always and until the end of time. You will always be my baby boy. Can't wait to hear your voice, son. You're never alone. We're all with you. Loving you, praying for you, and you forever. On Facebook and TikTok, update about missing Lawrence T. 31 reward. Please share. Scar on his upper left cheek. Tattoo of Homegrown on the right wrist. Children's name. Athena and Lawrence written on the front torso over his heart. Last visual confirmation on videotape by police department at Greyhound bus stop on July 12, 2024 in Dallas, Texas. Unmet medical needs for at least 3 months before missing. And there he is, this gentleman right here. There he is again. So there's a mama's plea right there. Um, so sad. So sad. I've heard that too, Texas. I've heard that, there's been a lot of suspicious activity in the hospitals. He was at the state jail and released. So he went to safety special needs. He unsuccessfully completed that. They sent him to the state jail for 90 days to continue his sentence. So he completed that. They gave him a bus ticket, obviously to Dallas. I guess he was going to a treatment center there or something, or some kind of place. And that's the last they heard about him. If you've ever been to Dallas, Texas bus station, that place is a counterculture of its own. It is the most treacherous, shady, drug infested, criminal infested place I've ever been in my life. I've been through there about 3 or 4 times. I stayed on the bus. I didn't even get off the bus. I mean, it was just like, it's just terrible. I wonder that too. I mean, that was part. I mean, I know a little bit about this guy, and that was part of his stuff was that, but still doesn't minimize the fact that he's missing. You know what I mean? I hope I hope nothing bad has happened to him. I hope that he's found for his mother's sake and his family's sake, because even if he is 31, I don't believe that anybody that is on mental health medication and they haven't been on them, chances are he's not in his right mind and he might not know where he's at or what he's doing. And he might be self medicating on the street. He might be somewhere safe, but he just out of it because, he may have relapsed. You just never know. Just never know. You say it's about as bad as in Detroit. I've never been to Detroit. So that's true, Texas. That's true. And when they release you, they give you a voucher and $50, I think. So I think that he would have had like a little bit of money on him. But that bus station just terrible, man. Just been countless assaults, abductions, all kinds of stuff at that bus station. So I just hope she finds her son and he's well, or if he's not, that she's able to help him, because she just lost her husband probably 2 years ago to something tragic. So she's a good person, and if anybody in our families ever go missing, we deserve to know what happened to him and find him. My cats be acting like crazy. We had a tornado warning. They had to spend 45 minutes in the bathroom with their little box. I'm sorry to hear that. I hope the weather got better. I don't know where you're at, but I hope the weather got better for you guys. Hope nothing bad touched down in your area. I hear Florida's got a bad hurricane in that area, so if you're in Florida, send the prayers your way. And any place that's being affected by that hurricane, sending prayers your way. Hopefully everything turns out okay. Northeast Ohio, no, nothing bad happened. Well, that's good, but Ohio, another one from Ohio. Chickbait, where are you at? Texas, did y'all get any of this rain that we got over the last couple days? We got quite a bit of rain on Saturday, a little bit of rain on Sunday, but it's freaking hot as heck again today. I'm ready for fall weather. I don't know about you guys. Just ready for it to cool down. But you guys, um, those of you that listen or just pop in to listen and don't chat, and if you've been listening for a while, you know what type of individual I am. And I don't mean any harm to anybody or anything. I'm just very blunt and very honest about my thoughts. And sometimes I type in very honest and bluntness because I've worked with the criminal justice system for about 24 years now. So you don't have a lot of time when you're doing your documentation and stuff, and you got to be very direct and very to the point. You don't have a lot of time to mix your words. And if you ever take any of it for being rude or obnoxious or anything like that, I do apologize in advance because no harm intended. It really isn't, you know? So just want to jump in and say hi to everyone. We're going off to bed, have a 10-hour road trip to Boston. Will you be careful on that road trip? Safe travels. Thank you for being here. 90 degrees in Portland. Dang. Corral two cats. Get them in the crate. Good luck. Good luck with that. Cats are not easy to corral, especially if they're bigger cats. But I just wanted to say that to you guys, that if you pass that along to anybody who has kind of lost interest in the channel due to my abrasiveness, it's not because it's intentional. A lot of the times I don't have a lot of time to be spitting out a lot of things. So I say things in the most direct way possible, you know? I bet, Rondi, I bet. 90 degrees and the water's freezing. Yeah, that tells you a lot that the weather's changing. Well, thank you so much. Well, you guys, I'm going to call it a night. You guys, thank you for being here again. Thank you for supporting the channel. And I hope you guys stay safe wherever you are. And if you're new to the channel, please come and keep coming back. And there's a library full of videos. And I will probably continue this court process. And also gonna start, since I'm doing the criminal mind this semester, I'm gonna probably do a lot about the criminal mind as far as true crimes involved. You know, I'm gonna eventually finish up the cases that I started, the Carly Gregg, the Alex Murdaugh, and the TikTok murders. I haven't forgot about them. I just didn't feel like doing any of that tonight. So I hope you guys have a wonderful evening. And I'm going to ask you guys in chat, can you dig it? Can you dig it? I hope you can, because if you can't, get a bigger shovel. Maestro, cue that music.